All right, here we go. We're going to pick up the second part of the rights of the accused. We're going to start off with the Fifth Amendment. You cannot be tried twice for the same crime. It's called double jeopardy. Again, these are rights that are provided to you from protections from the government. So you cannot be tried twice. You do not need to testify against yourself. That's where the phrase "I plead the fifth" comes from. We call that self-incrimination. And if this is where they reinforce this concept of due process. There is a process, and you're allowed to to make sure the steps occur in a very specific order. And another part of the Fifth Amendment, it talks about eminent domain. The government cannot take away your land unless it pays, and it has to be a good reason. Until this case. So if you look here, the Supreme Court, private property, knocking down private property. They can only do it for a good reason, like a hospital or a highway. Watch this video. It will. It is a new shift from the Supreme Court.
This is the so-called takings clause in the Fifth Amendment. It enshrines your right to private property without undue government interference. Traditionally, takings for public uses included highways, schools, and other government-owned and operated projects. But in 2005, the Supreme Court turned that notion of public use on its ear.
Economic development, the payment of higher taxes or the creation of more jobs is now a public use under the Fifth Amendment to the U.S. Constitution. A very dangerous precedent that the court set, but as I mentioned, that has led to this this backlash against what I think it's fair to call the most universally despised Supreme Court decision, perhaps in its history.
My name is Suzette Kelo, and the government stole my home.
Suzette Kelo is an American hero. She is a woman who stood up for her rights, and in the process stood up for the rights of all Americans. She was a homeowner in New London, Connecticut, that simply wanted to keep something that was incredibly valuable to her, the first home that she ever owned.
For Suzette Kelo and her neighbors, that Supreme Court decision was a profound disappointment that capped an exhausting legal battle.
Over 10 years ago, I was lucky enough to find a great deal on a house with a terrific view of the Thames River, the Long Island Sound, and the Atlantic Ocean in New London, Connecticut. I spent every spare moment fixing it up and making it the kind of home I had always dreamed of. I'm sure you've heard the expression, location, location, location. Well, this was the wrong location, only I didn't know it yet.
Just after Suzette Kelo bought her little pink house in 1997, the Pfizer Corporation announced it would build a massive new research facility in Kelo's Fort Trumbull neighborhood. The city council approved plans in January of 2000 to help Pfizer acquire the land it wanted in New London. The plan made dramatic use of eminent domain, and it was all in accordance with state law.
The group that had the power, I think, also had some arrogance. And I think they understood that the law did, as the law was written in Connecticut, they did have the power to do what they were doing, as wrong as it seems. And as long as anybody was going to challenge them or fight them, they were going to enforce the law and exercise it no matter what. And I think the more the homeowners dug their heels in, the more the people with the power dug theirs in and said, well, we'll show you.
The homeowners who wanted to stay were served with eviction notices the day before Thanksgiving in 2000, but the legal battle between the Fort Trumbull residents and the city continued for 5 more years.
The Supreme Court has agreed to decide if governments can seize people's homes and businesses for economic development projects.
The High Court heard the case in 2005, and it was to be the most despised Supreme Court decision in many, many years.
What the Supreme Court basically said was our land was only our land until someone else could make better use of it and pay more taxes.
Justice Sandra Day O'Connor wrote in her dissent, "The fallout from this decision will not be random. The beneficiaries are likely to be those citizens with disproportionate influence and power in the political process, including large corporations and development firms." Justice Clarence Thomas wrote in his dissent, "Something has gone seriously awry with this court's interpretation of the Constitution."
If there's anything that I think should take high priority in America, it is the protection of private property.
This is something every American and certainly every member of Congress can identify with.
Reaction to the 5-4 decision was immediate and forceful.
As a result of the Supreme Court's unbelievable ruling, a majority of the states have passed legislation offering more protection to American property owners.
They certainly felt the pressure of the public. I mean, a lot of legislators told me as I was talking to them and lobbying for this legislation throughout the country that they've never had phone calls like they did in reaction to any court decision, whether it's from the Supreme Court or any other court.
The reason this case became what it is today isn't because the Supreme Court said 5-4, you can do this. It's because how the general public across the United States reacted to that decision.
And though it may be a small consolation, the project that cost Suzette Kelo her home has essentially gone nowhere.
3 years later, Kelo's house has been torn down, and the lot where it once stood is vacant. In fact, Real Clear Markets reports that there is no new construction in the area because the city-sponsored developer has been unable to secure financing because interest in the project is minimal.
There's absolutely no new construction in that area whatsoever.
There's nothing there, nothing at all.
They haven't built a thing. They've knocked a lot of things down, but they haven't built anything. And as far as job creation, job stimulus, the only jobs that have been generated there have been for demolition crews.
There were 78 houses there, 78 tax-paying residents. Now there's nothing there. There's certainly no taxes.
There's likely to be no new development in that area anytime soon.
All it is now is a dust bowl, really, and I really hope they choke on the dust.
I think ultimately the Supreme Court will hear this issue, and I think they will reject Kelo. I think Kelo is one of those decisions, like Plessy versus Ferguson and Korematsu, the case that upheld the internment of Japanese citizens, is destined to be overturned. And I think it's only a matter of time before that happens.
Okay. I like showing that. I really do believe that it provides a powerful human element to the Bill of Rights. Each one of these cases is a human face to the Bill of Rights. You just have to filter down and get the facts. Many of these are quite powerful. Let's move on to the Sixth Amendment, which provides a right to an attorney and a right to a speedy trial. Again, impartial jury, not favoring any side. And you must be told of the charges against you and to be able to confront your accusers, which is what we call the writ of habeas corpus, is being told the charges against you. If you look at the lower left-hand cartoon, that is a picture of Guantanamo prisoners who for years were never told the reason why they were being held. And you must be provided a lawyer if you cannot afford one. And then finally, the Eighth Amendment talks about no cruel or unusual punishment. And again, punishment occurs after the trial. It also says no excessive bail. Bail is what might be set to see if you can go home before and during the trial. Again, if you take a look at the upper right-hand side, you see an electric chair. Would that be cruel or unusual punishment? Lethal injection on the lower left, and then lower right, this person has to wear a sign saying, "I am a thief, I stole from Walmart." Is that cruel and unusual? The bottom line is this person chose to wear that, so that is not a violation of the Eighth Amendment. It was either that or spend 3 weekends in jail. She had to spend 2 Saturdays, 8 hours each, holding that sign. And then ultimately, we want to hit the 9th, 10th, and the 14th Amendment. The 9th Amendment basically states that this is not a complete list of rights. There are more. The 10th Amendment reinforces federalism, that all the powers not given to the federal government in the Constitution go to the states. for example, voting and education, not mentioned in the Constitution, so those are state responsibilities. And then finally, the 14th Amendment. 14th Amendment basically say that the states must follow the Bill of Rights. If you recall, the Bill of Rights protects you from the federal government. We know that. That's why they did that. And then ultimately, though, with the 14th Amendment, this states or says that the states must follow the Bill of Rights. And since they couldn't do it all at one time with a blanket incorporation, they have to wait till cases come to them, and that's what we call selective incorporation. Like Mapp v. Ohio incorporates illegal search and seizure, and we call to the states, and they developed this thing called the exclusionary rule that we talked about in the last PowerPoint. There are two huge clauses in the 14th Amendment. One is the Due Process Clause, and it basically protects you from the government, which is what we call civil liberties. There's also an equal protection, which we call civil rights. Government will stand next to you to make sure that you are being treated fairly and equally. So those are the two clauses in the 14th Amendment. In the end, a lot of information in the Bill of Rights, and hopefully this provides a clear explanation of some of the information found in your textbook. Again, I would reiterate, if you have any questions as you're writing this stuff down, write some questions in the margins. I will do my best to answer them, and before I even try to answer them, we'll throw them to the class to see if they can explain. And I believe that is it.